Assalamualaikum and a very good day, everyone. My name is Umaira Patricia binti Hayat Al-Mazli with ID 2023197209 from Class E for Bachelor of Law. I'm going to present my answer for the question of tutorial 3. The question is, briefly discuss the Chinese and the Hindus practices before the enactment of the Law and Reform Marriage and Divorce Act 1976. Secondly, explain the effects of the statute on the two customary law. 20 marks. In answering this question, I'm going to use the method of introduction, body, and conclusion. For the introduction, its customary law is the usual and commonly accepted social behavior in a society that became binding. Although it's just a custom to begin with, it still has the legal consequences upon its breaches. Hence, it invokes legal sanction. In Malaysia, there are few customs that remain standing until today, which are the Malay, the Chinese, and the Hindu customary law, Orang Asli customary law, and also the native customary law that applies only in Sabah and Sarawak. As per question asked, we will indulge in the depth of the Chinese and the Hindu customary law, as well as the Law and Reform Marriage and Divorce Act 1976 effect. For the content, the first paragraph is the first government was a coalition of Malaysia, Chinese, and Indian parties called the Alliance Party. This successful multi-ethnic collaboration continues until today. Today, the Chinese form about 35% of the total population. Ab initio, the Chinese customary law come in hand to be implemented during the colonial period on the purpose of protecting the immigrants' right. As for that, British recognized the laws of China, then restructuring it, and amendments were made, resulted to Chinese customary law. This is because the law of China from the Qing dynasty were not considered as suitable with the local condition in the 9th century in Malay Peninsula. The courts created a uniform body of Chinese customary law which applies to everyone who's originated from Chinese race regardless religion or domicile. The court recognized the Chinese customary law with the scope of polygamy, marriage ceremony, divorce, charitable trust, and adoption. Polygamy stands for the practice of having more than one spouse at one time. The Chinese practice of polygamous unions has the same requirement in forming a valid marriage between the Tsai, a primary wife, and the Tsip, the secondary wife. It is stated that it requires only three elements, which are the long-continued cohabitation, intention to form a permanent union, and also a public repute. Traditionally, Tsai is upheld as a higher status than Tsip, the secondary wife. However, the court accorded both as equal in status. Besides that, another evidence of the Chinese customary law implementation in the Malay state was the Para Order in Council No. 23 of 1893 as amended by Order in Council No. 26 1895. The order is about when a Chinese couple were allowed to adopt a child from another family, and subsequently they are allowed to apply their surname as the child's family name. The court recognized Chinese custom more likely as a natural justice. Into the customary law, the Hindu customary law acts vice versa compared with the Chinese custom. The development of Hindu customary law in the Malay Peninsula is the extension and adaptation of the Hindu customary law in India. The Indians were mainly employed in plantation industry during the Malay Peninsula Rising era by companies such as Sime Darby. Nevertheless, the recognized Hindu customs were only the ones that do not act contrary to reason, justice, and to the general public policy. The subject matter to judicially recognize are marriages, divorce, and also inheritance. Within the field of personal law, Hindu customary law has its unique features, which are the joint family property and also the money lending contracts in the Chettiar community. To be highlighted, the previous Chetty money lending community system is different with the money lending scheme in these modern days. In evidence to the following statement are in the case of Puta and Vali Uta Devin and Anor in the year of 1883. The court assumed the relevance of Hindu law without argument, which is the right of a Hindu wife to hold a realty as a separate property during the coverture. Moving on to the law and reform, Marriage and Divorce Act 1976 impact on the custom of Chinese and Hindu, which it varies. The sole purpose for this act was to regulate and standardize the methods of marriage and divorce among the Chinese and Indians. The effect of the act inter alia touch on the abolishment of polygamous marriage, registration of marriages, solemnization of marriages, and ground for divorce. The abolishment of polygamous marriages introduces monogamy through Section 5 and Section 6 into the community. Therefore, it forbids contracting further marriage during the continuance of the existing marriage. Breach of the said Section 5 and Section 6 constitute to committing the offence of a bigamy, which entitled of 7 years of imprisonment, if found guilty. Secondly, Section 33 and Section 34 of the Law and Reform Act 1976 provide the requirement for registration of marriage, thus to remove any doubts of cohabites and the children of such unions. According to Section 33, provides for voluntary marriage registrations. As for Section 34, any marriage before the 1st March 1982 that executed with the following customs are considered a valid marriage. Also, the marriage was not registered formally to the registry committee. Therefore, it is validated all customary marriages that were not registered before 1st March 1982. For instance, the case of Leong Wei Xing and Chai Siu Yin 2005, it was issued that the plaintiff marriage was void for non-registration at the Registry of Marriage. However, the court held that the Section 34 has been satisfied upon their proper solemnization. Moreover, for the solemnization of marriage, it is mentioned in Section 22, Clause 1, Para C of the Law and Reform Act 1976. The section stipulate that customary marriage may be affected by two compulsory conditions, which are the marriage has to be solemnized by a registrar or any religious officer according to each custom and religion. Secondly, the couple must submit a statutory declaration of their marriage to the assistant registrar. The registrar would issue a certificate of marriage after the solemnization. Marriages in the premise of church, temple, or any clan association premises as may be permitted by the religion or custom to the parties. Last but not least, the Law Reform and Marriage Divorce Act 1976 affect the ground of divorce of each custom by providing Section 51, 52, and 53. In the Act, Section 51 explains the dissolution on the ground of conversion to Islam. It is said, if one party converted, the other party may set for a petition of divorce. The petition has to be presented before the expiration period of 3 months from the date of the conversion. Section 52 is when the dissolution by mutual consent from both husband and wife. Their mutual agreement to divorce may come into force after expiration of 2 years of their marriage present a joint petition. The court also may make a decree of divorce in which as it thinks may fit to support the care and the custody of the subjected children. Meanwhile, Section 53 is about a breakdown of marriage. Either party to a marriage may petition for a divorce on the ground that the marriage has irreversibly broken down. The court hearing such petition shall, so far as it reasonably can, make a decree for its dissolution after inquiring to the alleged facts. In conclusion, the Chinese and Hindu customary law is designed to be adapted with the society flow. The adaptation resulted to an amended set of law called the Law and Reform Marriage and Divorce Act 1976. Inevitably, the Act has ignited a standardized custom law between the Chinese and the Indians, in which created a harmonious society that could live along despite the indifferences. Thank you.